StudyIQ IAS, अब तैयारी हुई अफोर्डेबल।
Hello everyone, I hope this message finds you fit and fine. My name is Shashank and I welcome you all to this class. Please confirm that my voice is fine. Just mention in comments and we are all set to start. In our previous class, in our journey in part 3, Fundamental Rights, we were discussing Article 21. And within that discussion, I mentioned Maneka Gandhi case and how it enhanced the power of Supreme Court from procedure established by law to due process of law. It means now judicial review was happening in context of both executive as well as legislative actions of the government. And when I say legislative, it means legislature. After that, I mentioned Mohini Jain case, Unni Krishnan case, and how all three cases made the background for inclusion of Article 21A, right to education.
कई बार मन में सवाल आता होगा कि इस प्रिपरेशन को शुरू तो कर दिया है, मज़ा भी आ रहा है, तभी आप इस वीडियो में हैं, सीखने को तो मिल रहा है, लेकिन क्या उतना पढ़ा जा रहा है जितना इस एग्ज़ाम को क्लियर करने के लिए ज़रूरी है? क्योंकि अल्टीमेट ऑब्जेक्टिव तो क्या है? योर नेम इन मेरिट लिस्ट। तो देखिए, कंटेंट तो सेम है, लेकिन कंटेंट को यूज़ करने की हमें स्किल डेवलप करनी है। कैसे होगी वो स्किल डेवलप? पहले तो भाई टाइम से हर एक सब्जेक्ट का कंटेंट तैयार होना चाहिए। अगर आप वो कर रहे हैं, ठीक है, लेकिन इफ़ यू वांट टू टेक हेल्प तो आप स्टडी आईक्यू की हेल्प ले सकते हैं। जो स्टडी आईक्यू का P2I प्रोग्राम है, आप स्टडी आईक्यू ऐप या वेबसाइट पर देख सकते हैं। P2I मतलब प्रीलिम्स से लेकर इंटरव्यू तक का एक प्रोग्राम। तो ये एक प्रोग्राम के अंदर 4 फेजेस हैं। तो उस 4 फेजेस के थ्रू पहले ही फेज में आपका कंप्लीट सिलेबस हो जाएगा। तो इट इज लाइक द बेसिक थिंग, ये तो करना ही है। इसके बाद आता है कि हमें स्किल्स डेवलप करनी है, यानी कि उस कंटेंट का प्रीलिम्स में इस्तेमाल हो सके, उस कंटेंट का मेंस में इस्तेमाल हो सके, यानी कि आंसर राइटिंग। फिर हमें असेसमेंट चाहिए बीच बीच में, जिससे कि हमें कमियां पता लगती रहें। तो इसके लिए भी P2I में आपको प्रीलिम्स मेंस दोनों की टेस्ट सीरीज दी जा रही है। वीकेंड पर भी टेस्ट होते हैं, प्लस डेली मेंस आंसर राइटिंग होती है। तो आपको नहीं लगता अगर इतना कोई मेहनत आपके साथ कर ले तो आप करना तो चाहते हैं, बट एक पाथवे नहीं है, तो P2I प्रोग्राम वो पाथवे आपके लिए साबित हो सकता है। तो टेक हेल्प ऑफ दिस। फिर आपके मन में कभी कभी जो डाउट आता है उसको ढूंढने के लिए आपका काफी समय जाया हो जाता है। जाया इसलिए कह रहा हूं क्योंकि हो सकता है उस डाउट को ढूंढने के लिए आपने 1 घंटा लगा दिया, क्योंकि उससे एसोसिएटेड काफी सारी चीजें नई नई पता लगती चली गई आपको। ऐसे में इस टाइम को रिड्यूस कर सकते हैं आप। एग्जाम ओरिएंटेड क्या उस डाउट से रिलेटेड नॉलेज आपको चाहिए, वो आपको एक पर्सनल मेंटोर बता सकता है। तो इस कोर्स में फैकल्टीज तो आपके साथ हैं ही, इस पूरी जर्नी में आपको पर्सनल मेंटोर दिया जा रहा है, आप उसकी हेल्प लीजिए। आप कॉल व्हाट्सएप पर कभी भी उनके साथ कनेक्ट हो सकते हैं। उनका नंबर आपको इस कोर्स में स्पेसिफिकली आपको अलॉट होगा। तो अल्टीमेटली आपका टाइम बचेगा, कॉन्फिडेंस आएगा प्रिपरेशन में। फिर जैसे आप प्रीलिम्स क्लियर कर लेते हैं तो उसके बाद मेंस रेजिडेंशियल प्रोग्राम, ये इसका सेकंड फेज मतलब थर्ड फेज कहिए, क्योंकि पहले फेज में फाउंडेशन है, फिर सक्सेस इन प्रीलिम्स है, फिर MRP मेंस रेजिडेंशियल प्रोग्राम। फिर उसके लिए आप दिल्ली बुला लिया जाता है आपको। यहाँ पर आप मतलब जो फूडिंग लॉजिंग एवरीथिंग इज टेकन केयर बाय स्टडी आईक्यू। और उसके बाद फिर रिगरस प्रिपरेशन होती है आपकी मेंस के हिसाब से, यानी कि हर एक जो आपका पेपर है, GS है, लैंग्वेज है, essay है, हर एक की तैयारी यहीं पर हम आपको अपने सामने कराते हैं। उसके बाद जैसे आप मेंस क्लियर करते हैं तो इंटरव्यू गाइडेंस प्रोग्राम, वहाँ पर आपके कोहोर्ट्स बनते हैं, जिसमें डिस्कशन के थ्रू जो आपके अदर एस्पिरेंट्स हैं, जो आपके साथ इंटरव्यू देने वाले हैं, तो आप अपनी स्किल्स को पॉलिश करते हैं। साथ में ब्यूरोक्रेट्स, फॉर्मर टॉपर्स, ये सब फैकल्टीज आपको मिलकर गाइड करते हैं। फाइनली व्हेन यू आर थ्रू इनटू द मेरिट लिस्ट, देन फिर आपको लगता है कि हाँ, इट वाज ऑल वर्थ इट। मिलते हैं आपसे क्लासेस में, ख्याल रखिए। जय हिंद।
I hope you remember. So today we are going to start from Article 21A. As you can see, the language. State shall provide. It means it will be responsibility of state. Now the point is, our constitution was already having provisions with respect to state having this responsibility towards education of children. But this is mentioned in DPSP, Directive Principles of State Policy, which are not enforceable by court, right? By inclusion of these principles in fundamental right made them enforceable by court. It means children belonging to this age group, if they're not having education service in their vicinity, that's a criteria that administration is going to decide, then they can actually claim that I'm not having this facility, then the state is bound to provide that. Now, my point is, can you actually mention one government scheme which take care of nutritional and preliminary education aspect of children before 6 years of age? Can you mention that in comment? Come on. I'm repeating my question. I'm saying right to education, Article 21A, make this mandatory over the state to provide free and compulsory education for children between 6 to 14 years. My question is, can you mention a government scheme which takes care of nutritional and preliminary education aspect of children before 6 years of age? Government scheme I am asking. Answer is ICDS, Integrated Child Development Scheme. You must have heard about Anganwadi centers. So Anganwadi centers are established under this scheme. Okay. Now this Article 21A was added through 86 Constitutional Amendment Act. That's a fact. Now this is clear to you. Now talking about Article 22, the language says protection of life and personal liberty with respect to, these two words are used in this particular article, punitive and preventive detention. First understand the difference, and then we are going to discuss what kind of protection we are talking about. Okay. Now, punish a person for an offense means when the word punitive is mentioned, it means you have committed some crime. Administration has proved that you have committed some crime. On these grounds, this detention will happen. Okay, even if you have not committed, but why you are going to be arrested? Because they have a proof that you have committed that crime. Okay, but when it comes to preventive detention, it means police department do not have any proof, and they also do not consider that you have committed some crime, but they are detaining you for prevention of law and order, because you can be a security issue if you are left alone freely in this society. Okay, we discussed this preventive detention in A.K. Gopalan case as well when I mentioned section 14. Now the prime focus of this Article 22 is the facility which is provided to you. It means if you are arrested, say in case of punitive detention, then it says who is arrested shall be detained in custody without being informed. It means you should be informed. Informed should be the keyword. And you should be allowed to consult a lawyer, legal practitioner of your choice. Number 2, these are 2 rights. And within 24 hours, you should be produced before a nearby magistrate. And this particular provision is also connected with this fact that if magistrate allows that you should be free, then you should be free. Okay, it means your detention beyond 24 hours will happen only on the direction of magistrate. So this protection is available to you in case of arrest. That is what, or you can say detention, that is what Article 22 is talking about. Also keep in mind, these rights are not available to enemy alien or person detained under preventive detention law. Now, I'm asking, consider someone is arrested, for example, in case of Delhi riots. Many people were arrested under UAPA, okay, Unlawful Activities Prevention Act, okay. Is it mandatory that if someone is arrested under UAPA, that person should be produced before magistrate within 24 hours? This is a question in front of you, because there were many articles in news regarding UAPA and some of the provisions which were questioned that these are draconian provisions and abused. So that's a question from you, for you. UAPA, star point. Okay. Now, the 44th Amendment Act 1978. So it reduced the period of detention about obtaining the opinion of an advisory board from 3 to 2 years. Now, what is the context? In case you are detained in, say, with regard to preventive detention, then the law says you cannot be detained beyond 3 months. If you are detained beyond 3 months, then it can be done on the direction of an advisory board, and High Court judges can be member of this advisory board. Okay. Now, but 3-month detention can be done, right? Now, 44th Amendment Act 1978, it reduced this 3-month to 2 months, right? But the point is, the fact is that it is not applied. That is why I'm saying this provision is not yet been brought to force. Hence, the original period of 3 months is still continuing. So these are the example of some preventive detention laws. You must have heard about MISA, Maintenance of Internal Security Act, right? Some provisions like TADA, POTA, so they have some provisions with regard to this. This is UAP, Unlawful Activities Prevention Act, which I have just given you as a star point. Now, we need to talk about right against exploitation. Here we talk about 2 articles only, Article 23, Article 24. Article 23, it says prohibition of human trafficking and forced labor. And within this, it mentions word like human trafficking. What is human trafficking? It is buying and selling of human. Okay, if such thing is happening with you, then it is against your fundamental right as mentioned under Article 23. Okay, what punishment will be given if such thing is happening with you? That is not mentioned in Article 23. Okay, for this you need to refer a specific law made by Parliament in this regard. Apart from this, begar, bonded labor, forced labor, they are also prohibited under Article 23. Now I am making a statement, I expect you to answer. Okay, statement is, a state cannot make any law compelling people to work without giving them due of their labor. You have to tell me the statement is true or false. I am repeating my sentence because I mentioned that forced labor is against Article 20, forced labor is against a fundamental right. It is mentioned in Article 23. I am saying state/government, means I am referring to government, cannot make any law making citizens do some work, binding you do some work without any due payment regarding your labor which you have done. So that statement is true or false? Come on. And it is a rapid fire round, so I request your responses to be quicker. Welcome Sanjay, Sajal, Chelvaraj. It doesn't matter whether you answer right or wrong. What matters is that you have attempted this question. Come on. Should I repeat the question? Everyone, bring your presence into the comment box. जिंदा हैं तो जिंदा नजर आना भी जरूरी है. So here you can do that by being in this comment box. Interaction is necessary, otherwise it will be a pravachan class. I don't want that to happen. Answer is false. Now some of you might say that sir, forced labor, and in this part of statement government is actually forcing us to do something by law and not paying us. So in this case, government can compel you to do this for national service, okay, but not private party. Okay, this is the differentiation. So it is available to citizens as well as non-citizens. It also need to be, You should keep this in mind. So human trafficking in the form of, I told you, buying and selling of men, women, prostitution, devdasis, slavery. Okay. Apart from this, it also says protection against state and private individual. It means it gives protection to citizens as well as non-citizens, and protection against state as well as private citizens. It means no one can actually do this with you, right? And force means physical, legal, economic compulsion. Okay, when I say compulsion, it means if you are paid less than the minimum wages law which is applicable in that state, then also it will consider as abridgment of your fundamental right as mentioned in Article 23. Okay, and when I say physical, legal, economic, it means if you are you made to do more work, right, that is also a part of, you can say, forced labor. Means in a circumstances which are not allowed as per labor law. Okay, then it will be a contravention of your right as mentioned in Article 23. Now these are some laws with regard to this Article 23. As I told you, Parliament can make law for your protection. Bonded Labor System Abolition Act 1976, Minimum Wages Act 1948. So this was an act made by Parliament, but various state governments also make their own act to regulate minimum wages, and that is why you will find a difference between the minimum wages prescribed between in Haryana to Delhi to UP. Okay, so minimum wages will be different. And why they are different? Because the living cost in different states and different areas may be different. Contract Labor Act, Equal Remuneration Act 1976. These are the example of the laws emerging from Article 23. Exception, I told you, government. Permit state means when I'm using the word state, what does it mean? You should refer the meaning mentioned under Article 12. To impose compulsory service for public purpose. Okay, for example, what is happening in Ukraine, you know. Right now, Ukrainian government is training their civilian for military purpose. Right? If such circumstances occur in India, then Indian government can also do. Right? And now you cannot say how much we are going to be paid for this work which you are compelling us to do. Then government will, and you are saying this will be abridgment of our Article 23, then government will say also read exception. Okay? So military service, social service, anything can be asked. Okay? No discrimination, caste, race, religion, class only. Means in this case there will be no discrimination, and these are the 4 criteria which are mentioned. Then we have Article 24, which talks about exploitation of child labor, or you can say child. So it is related to child labor. Please understand this particular article in 2 parts. It means what provision says in our constitution and what different laws says. What is the legal standpoint with respect to Article 24? Now, prohibition of employment of children, factories, etc. And why it was needed? Reason is that children are most ill-represented section of our society. For example, if women have certain issues, they think they are not having their rights in place, rights are not being enforced, then they can make association, they can ask, they can do you can say a movement. If a particular section, caste are not having their rights entertained, or they want more right, they can also have a movement, they can also pressurize government. But do you think same can be done by children? No. That is why it is our responsibility to ensure the rights of children, right? Because you should think that if this is the reality of our society, so you should think in a scale manner, how it impact the major landscape or the potential of Indian society, right? It is going to compromise on that. So it forbids employment of children below 14 years of age in dangerous jobs like factories and mines. Did not prohibit their employment in any harmless or innocent work. Now, please understand, there was a lot of, you can say, debate on this provision earlier. Interpretation was complete prohibition. But as it was found that time and again, reality is found that many people, many children below 14 years, they are engaged into various dhaba and other activities, and even family work as well. And there was another side, many government officials used to abuse this particular reality and barge into some work which is conducted by some, you can say, family together, and they are engaging some children. For example, Firozabad, you must have heard about the Bengal industry. So taking into consideration, now the idea is that they cannot be allowed to work in harmful circumstances. Another is they cannot be allowed to work in school time, okay, and beyond school time they can only be engaged in family work that is safe. Okay, so this was the definition. Although many child right activists were against this definition, some child right activists were in support of this definition. At least abuse of these families will stop. At least by this, many children will be actually getting opportunity to go into schools. Now, there are certain laws which you should keep in mind. For example, Child Labor Law, Prohibition Regulation Act 1986, renamed as Child and Adolescent Labor. Now, we have a law specifically establishing a statutory institution at the level of union as well as state for the protection of child rights in India. At the national level, we call it NCPCR. It means National Commission for Protection of Child Right, and at the state level, a State Commission for Protection of Child Right. So whenever it comes to the debate that whether child rights are being enforced, so at the state level you should put a question on SPCR, what is the status? You should conduct surveys, you should you can say channelize support from various stakeholders, be it civil society or government departments. You should ensure that. So SCPCR at state and NCPCR at the central level. Employment of Children Act 1938, Factories Act 1948. So these acts are still continuing. Mines Act 1952, Plantation Labor Act 1951, Beedi and Cigar Workers Act 1966. We have Children Rehabilitation and Welfare Fund. Now, please understand, from legal standpoint, our children are divided into two categories. Number one, children in conflict with law. Let me note it down so that you can connect it. I think black would be more visible to you. In conflict with law. This is one category of children. They also need some kind of protection, obviously, because the word children means they are not developed enough to decide their actions, what is good, what is bad for them. In conflict with law. Second is in protection, or you can say care, in protection care of law. It is also interpreted as in need of protection or care of law. Now, the Commission for Protection of Child Rights Act, so this is the overall organization responsible for this, NCPCR at center and SCPCR at state, in conflict with law. Whenever there is a case that some children have committed crime, so in this case, we have JJ Act, Juvenile Justice Act, which was also in news few times back, especially after Nirbhaya issue, right? So in this case, the decision is taken by JJB, Juvenile Justice Board, how much punishment should be given to this particular child who has come in conflict with law. Okay, for example, murder, dacoity and other activities or theft committed by children. Okay, but there are some children who are in need of protection of law. It means orphan, destitute. So in this case, we have a separate body, CWC, Child Welfare Committee. It is also known as Children Court. Okay, so two separate mechanisms are in place. And with respect to the definition of children in JJ Act, it was amended. And now when it comes to the definition, because general definition is that below 18 years of age, you are child, right, in eyes of law. But in case of Nirbhaya, you know that one of the culprit, he was found that he was less than 18 years of age, and that is why he could get a punishment of just 3 years, right, as per JJ Act. But later it was amended on the recommendation of Justice J.S. Verma committee report. And now if someone is between 16 to 18 years of age, in this case, to take decision whether this person is a child or an adult, this decision is taken by JJB. Juvenile Justice Board is going to take decision. If JJB said that person is 17, but the mentality of that person with which that person committed crime is an adult mentality, in that case, now that child, the earlier we were considering that person as child, now since JJB has declared him as adult or her as adult, now that person will be transferred to for a trial in normal court, means a sessions court if this case of crime, right? I hope it is clear. Now coming to right to freedom of religion, right? So we have two articles in this case, Article 25, Article 26. The major difference between two articles is that Article 25 deals with individual freedom with respect to religion. And when it comes to Article 26, it talks about religious, your freedom related to religion, but in terms of group institution, so that rights associated with managing the affairs of that particular, you can say, institution. Now, just check this question out. Right to freedom of religion means religious instruction shall be provided in all government education institutions. It's a quite direct question. I would appreciate if you attempt this question. Come on. I hope this is visible on your screen. Yes. Please answer in comments. एक तो होता है easy और एक होता है butter. So this question is like a butter. Religious instruction shall be provided in all education institutions. So this statement is wrong. No such case is there. Okay. Right to religion does not mean that in all the institutions this religious instruction will be provided. A state shall encourage religious thinking. Why would state encourage religious thinking? Bakwas hai ye, right? Give preference to person with religious bent of mind. Sarasar galat. Now, person shall have right to establish institution for religious and educational purposes. This is correct. So this is one of the right you have in right to freedom of religion. So answer is C. Okay. Now let's start with Article 25. Now let's take a look over what actual clause says. Okay. And I'm also going to ask one question from this particular article. Article 25 of the Constitution guarantees freedom of religion to all persons in India. Please give your focus. The word persons is used. Okay. It is not citizen, right? And I told you clearly that at some places the word is person, at other places the word is citizen, right? And another word which we are going to find in Article 29-30, that is minority. Okay. So now it provides that all person in India subject to public order, morality, health and other provisions, means these are reasonable restrictions. It means your right to religion should not contravene public order, right? You cannot say I am going to exercise my right to religion and I am going to conduct a ritual in between highway. Okay, I'm not going to stop this ritual because this is my faith and this is my fundamental right under Article 25. So if you try to do so in between highway, then you will find a police party which will take you to the Havalat to do some seva. Okay, because expressively, but it is clearly saying that it is not available in case you disturb public order, morality, health, and other provisions. Okay, are equally entitled. Now these are your rights. Freedom of conscience. What does it mean? It means you can have belief in whatever religion you consider fit for you, right? So that is at your internal level. Have the right to freely profess. Now profess is connected to your declaration, yes, this is my religion. Practice includes you conducting ritual, prayer, and other practices which are associated with that religion. And propagate religion, and you also have this right as fundamental right under Article 25 that you can propagate your religion, propagate the ideas of religion so that other can also follow your religion. But as I told you, our fundamental rights are qualified in nature, so that is why we have restrictions here too. Now let's go word by word. First is conscience. It means you can choose the path you want to follow. Profess, you can declare your faith. Right to practice means ritual, ceremony, exhibition, worship, belief, idea. All of this comes under right to practice. Right to propagate. Transmission of one's belief. No right to forcible conversion. Now, take example. If Sajal wake up next morning and he talked to his mother and father that last night I had a dream and I want to convert into another religion because God has given me this message, and he is about 18 years of age and he has also gone through polity. So his mother and father will say, no, you cannot do this. So he will say, if you try to stop me, I will go to Supreme Court using Article 32 because this would be against my individual right as given in Article 25. Because I have conscience, I have professed to declare religion, and I have this right to practice. And he also started from that evening he started practicing that religion. Now, in the night he met his siblings, and now he exercised another right to propagate his religion. So as his mother, father were looking at him in anger, he said, no, you cannot do so. Article 25, right to propagate. I'm going to propagate my religion among my siblings. Now, so his siblings are not interested to actually go his way. So what he did, he brought some chocolates and he presented that if you convert into my religion, I'll give you chocolate. Now, do you think that is also his right under right to propagate? No. Some of you might say, sir, this is forcible conversion. But giving chocolate is not forcible. That is a choice. If they are lured towards chocolate, then they are converting. So is it against this? Is it covered under this? No, it is not covered. It means when I say forcible conversion, it includes whether you must use muscle power, or whether you use any kind of arm twisting, or whether you lure that person for any kind of money or gifts. That will also be considered as that will be considered as illegal. Okay, that is not covered under your right to propagate. Now, it further provides that this article shall not effectively affect existing law and shall not prevent the state from making any law relating to. What does it mean? It means you have this right, but a state can actually intervene in your religion also in case regulation or restriction of any economic, financial, political, any secular activity associated with religion practice. Consider your practice, your ritual is contravening into fundamental right of a large section. Can state allow you to do that? No, state cannot allow you to do that. Take example of triple talaq, Sabrimala temple issue. What was happening? In Sabrimala temple issue also, one section was saying, those who were restricting the entry of women into Sabrimala temple, they were saying that Supreme Court analysis or judgment is against our Article 25 and 26. Why 25? They were saying this is our individual belief that women should not be allowed because Lord Ayappa is celibate, brahmacharya. So at that point of time they said no, a state can intervene, right? If it is against the definition of morality and it causes public order, disorder. So, and you know, in this particular judgment, this word also became popular, constitutional morality, right? And UPSC also asked question from that. Now, providing social welfare and reform, and you can also see that Sabrimala judgment or triple talaq judgment are considered as a reform, and this has been done by state. Opening of Hindu religious institutions of public character for all classes, sections of the Hindus. This is expressly mentioned in under Article 25. Now, some of you might think, why constitutional framers specifically mentioned the case of Hindus? Why not other religion? First of all, you should know who are covered under this definition of word Hindu. And there's a debate over it, obviously. But the definition include Hindus, Sikhs, and Jains. Apart from this, you should also know that why this provision is mentioned specifically on Hindus, because in Hindus it is found due to this caste discrimination, a section of our population is not allowed to access these religious locations, for example, our temples. So this is against their Article 25. This is clearly mentioned in our Article 25. Okay. Now, recently you saw hijab debate, right? And some parents were saying, if we have to choose between hijab and education, we are going to choose hijab. Because what is happening is against our Article 25, because it is part of our right to practice our religion. So on this point, this judgment by Karnataka government that we are going to bring uniformity in uniform, right? And there will be a common code and hijab will not be allowed in school. So on this point, the counter argument was hijab is integral part of Islam. Can state intervene into a practice which is integral part of a religion? So now what is integral part of religion? This particular debate started from this Tilkayat Shri Govindalaji Maharaj case. So what Supreme Court said here, held that test to determine the actual status, whether this particular practice is an integral part of religion, it will be based on the belief which is held by majority of people of that religion. This was the analysis. You can read. What is an integral part of religious, whether it is regarded as integral to the community, that religion or not. So community is going to be, understanding the community is going to the basis to decide whether it is integral or not. Okay, for example, Kirpan, Kada. So these are considered as integral for Sikh because it was given as a sermon by the Guru. But same is not true. It is said that same is not true with respect to Islam. There's a debate going on. Some say it is, some say it is not. But you should know the case and what Supreme Court said, how it is going to be determined. So it is not going to be a unilateral decision of state. It will be based on the specific community. Now these rights are subject to public order, morality, as I told you, and state is permitted to, what state can do? Regulate, restrict, economic, financial, political, I have already told you, provide social welfare and reform to all classes and sections of Hindus, I told you. Now, next Article 26 is freedom to manage religious affairs. So when I say religious affairs, it means it is also about managing movable, immovable properties. So it means we are talking about ashrams, madrasas, temples, gurdwaras. So now every religious denomination means a organization which belongs to a particular religion. Okay, because if there is an ashram, so that ashram must be registered in someone's name. There must be some group which is actually taking care of this particular area. So the right to establish, you have right to establish, maintain institutions for religious and charitable purpose. This is a fundamental right under Article 26. Now subject to public order, morality, health, every religious denomination shall have this right. Okay, and what the rights include? You can manage this institution, establish and manage, to manage its own affairs and matters of religion. Now, this was the basis, this was one of the basis of the section which was opposing the move of Supreme Court in Sabrimala case. They were saying if Constitution itself is saying that in matters of religion we can manage our affairs, then how can Supreme Court intervene? To own and acquire movable and immovable property, right? To administer such property in a way they want, but as per law. It means law need not to be abridged. Now, I'm making a statement and you have to tell me that statement is true or false. Okay. As per under Article 26, a particular religious group has the right to manage its affairs. As an extension of this right, a particular religious group can excommunicate a particular person from religion. So that statement is true or false? Those who are wondering what is excommunication, it means you will be considered out of religion. So is it legally possible? Is it legally allowed that yes, it is a fundamental right under Article 26? Yes, no, yes, no. Come on. Question समझ में आपको? So answer is, it is not allowed. Okay. So prevention of excommunication, and this was Saifuddin Sahib versus State of Bombay case in 1962. And in this case, it was cleared. Excommunication means, I told you, the exclusion or expulsion of a person from a community or group which she was a member. And in this case, excommunication was declared void. Okay, it should be clear to you. Now, 3 conditions of religious institution. I'm using the word religious institution now. So what is religious institution? Can one fine day Sanjay Basi wala, so he can actually come up and say, I'm purchasing a property and this property should be considered as a religious institution. So there's a criteria to that. First of all, collection of individuals who have system of belief which they regard as conducive to their spiritual well-being. This is one condition, because this is a religious institution. It is not a private institution. It's not an individual. It is a group of individuals who are part of religion. Now, common organization should be there and designate. So they should have a distinct name. So this is the criteria to decide whether this institution is a religious institution or not. Please remember these kind of details, because UPSC play on these lines. And these are the kind of statements we often miss while reading Lakshmikant. Now, talking about Article 27, freedom from tax and promotion. It simply means government cannot impose a tax for promotion of a particular religion. What does it mean? It means one fine day, if one leader actually stood up and on television and he says, Bhai aur Behno, aaj raat 8 baje se, from today, from 8 p.m, now we are imposing another cess, that is Hindu Vriddhi cess. So can this happen legally? No. It will be considered as a contravention of Article 27. Okay. This example was given so that it can connect, well in your mind. Okay. Otherwise, we should have, since you have to be part of system, then you should be authentic and you should be neutral in your learning, understanding, and then expression. Please keep in mind. So no tax can be imposed for promotion of a particular religion. First of all, it prohibits only levy of tax. It means there's a difference between tax and fee. Fee can be taken from people who are participating in a particular, you can say, religious congregation or particular area. But tax is different. Tax is imposed on a particular category of people. Let me tell you the difference. If Kumbh Mela case is referred, so as you go to Kumbh Mela, so you will find that you have to pay a minimum fees of 5, 10, 15 rupees. So this fee is collected by government, and then government department spend this money for upkeeping of that area. So at that point of time, you cannot say, oh, government is actually using this money which government has got as a revenue for promoting a particular religion. No, because that was a fee. That was not a tax. Okay. It was not taken from all. It was taken from those who were coming into that area for getting the service of that area. Okay. No public money collected through taxes. It means one is you cannot impose tax to promote. Other is the revenue you have, you cannot use that revenue for promotion of a particular religion. Okay. That would be against secular credentials. So you can see that Article 27 is representing secularism. Favoring, patronizing a particular religion, that is prohibited. Okay. Purpose क्या है इसका? To control secular administration or religious institution, not to promote and maintain religion. So it is quite clear to you. I've explained this. What does it mean? Now, Article 28, talking about allowing or disallowing religious instructions in institutions. So just read Article 28 subclause 1. It mentions the word wholly maintained. No religious instruction shall be provided in any education institution wholly maintained out of state funds. And UPSC play on these words: wholly maintained, administered, established, funded, right? So you need to give attention to these details. Everything will be clear. Nothing in clause 1 shall apply to any education institution which is administered by state. Now, there's a difference. Wholly maintained by state means government is funding the whole institution as well as administering the whole institution, whole upkeep, so totally owned by a state. But in this case, it is administered by state, but established under any endowment, trust which requires that religious instruction shall be imparted in that institution. For example, what happened? Some you can say businessmen came together, they established a trust and they pooled their money, okay, and they established an education institution. But after that, they tied up with the government that we don't have know-how of running this education institution, so please you administer this education institution. It means when it comes to appointment of teachers, principal, staff, so these government employees will be administered by the government, and government official of that particular district will take care of the administration. But the establishment was happened by trust. So in that case, this subclause 1 is not going to be applicable. Okay, religious instruction may be given, but the word is may be given. I have not said you are compelled to actually be there and listen to those religious instructions. There is a difference between the two. As of now, we are talking about given or not given. Okay, no person attending any education institution, now it is about you, recognized by the state or receiving aid of the state funds shall be required. Now, recognized by the state, what does it mean? Every education institution which is working, majorly of education institution, they are recognized whether by CBSE, right, ICSE or any state government, right, receiving aid out of state fund shall be required to take part in any religious instruction that may be imparted in such institution. So you are not compelled to be there or to attend any religious worship that may be conducted in such institution or any premises attached thereto unless such person, or if such person is a minor, in that case guardian's permission is needed. Let me share one case. In one case where Kendra Vidyalaya was in news, two students, they came into the assembly and they said the prayers the prayers were starting from this mantra, the mantra which is belonging to obviously to Hindu religion. So they said we are not going to be part of this prayer. So the principal said no, it is a decision that every student should be part of the prayer. If you are not participating regularly, then it would be considered as indiscipline. Then these students said, and the parents said, actually this is against my my fundamental right under Article 25. Because my religion says that I have to uphold the practice of my religion and I should not do that. So that principal expelled those two students. So that matter was heard by Supreme Court. So in that case, Supreme Court said no. That these children cannot be bound to be participating in religious instruction. Okay. So this was coming from Article 28 subclause 3. So now I hope this is clear to you. This is a representation of the discussion which we just had. So now attempt this question. Institutions administered by state, established under any trust, government school, state university. Article 28 is applicable on. Come on. This is a good question. Take note, the word is administered. And you should also know that when UPSC is going to make a statement, UPSC will actually elaborate this. Okay, what UPSC will say? It will say that as per Article 28, no religious instruction will be provided in which of the following type of institution. This is how a statement will be expanded here. Consider this as a statement. Okay, then these options will be given. Then tell me what is the right answer. First of all, the word is administered, and I've already told you when I was explaining subclause 2 of Article 28 that please remember, these religious instructions are banned in wholly maintained institution, but it is administered, so it means this should not be the answer. Established under any trust, and within subclause 2 I also mentioned the trust case, so this cannot be the answer. A government school means wholly, wholly owned by a state, so it means this is true. A state university, it means it is also about government wholly maintained, so it means answer is 3 and 4. Okay, now I'm making last statement of my class. Last statement is, no government institution means wholly maintained by government, can give religious instructions. The statement is true or false. Some of you might think it is quite obvious, 28 subclause 1, but still I'm making the statement. The statement is, no government institution means wholly maintained by state can provide religious instruction. Its statement is true or false. Come on. Answer is, some of you might think it is quite true, direct hai, Article 28 subclause 1. But there is an exception here, and UPSC play on exceptions. Whenever you see a question whose language is absolute, means when you read, so it infers that it is true in every case, then your antenna should open. You should be on high alert that whether some exceptions can be there or not. So in this case, there is an exception. If there is a there is an institution which is wholly maintained or funded by state, or that institution was established specifically for religious purpose, in that case, this can happen. For example, Gurukul, for example, madrasas, for example, this Waqf board, right? So Waqf board managing some properties and government wholly funding and managing that property or education institution, then how can you say that religious instruction cannot be provided? That purpose of that establishing that institution is actually providing religious instruction, right? I hope now it is clear. So see you in the next video. For this PDF, you can connect with me in Shashank Tyagi for You Telegram group. You can shoot me a message if you find any doubt. I'll be there to help you out. See you.
StudyIQ IAS, अब तैयारी हुई अफोर्डेबल।